Thank you all for coming. We're delighted you would take the time and join us this afternoon for the first and the major public appearance of the 1987-1986 recipient of the Thomas Jefferson Award in Law. And before I introduce Judge Webster, I'd like to say just a word about the history of that award. It is given jointly by the University of Virginia and the trustees of the Thomas Jefferson Memorial Foundation, that is the owners and presiders at Monticello. It was their initiative indeed, and it parallels an award created approximately 20 years ago for a distinguished architect. It was decided roughly a decade ago that it was only fitting that the other great interest of Mr. Jefferson's life, the interest in law and legal institutions, should be recognized in an award to a lawyer of comparable distinction. And since 1977, this award has been conferred upon a list of people who do indeed exemplify the highest levels of achievement in the legal profession. They include Judge Carl McGowan, former Chief Judge of the D.C. Circuit, the late Judge Henry Friendly of the Second Circuit, Professor Paul Freund of the Harvard Law School, Erwin Griswold, former Solicitor General and Dean of the Harvard Law School, Justice Lewis Powell, Warren Christopher, Lord Leslie Scarman of the High Court in England, Griffin Bell, and last year's recipient was the retired Chief Justice of the United States, Warren Burger. We're very pleased today that we can have this year's recipient here to commence 2 days of visits to the university and to the law school. And it's a special pleasure to be able to join with the Student Legal Forum as co-sponsors of this opening event, this public appearance. William Webster is a respected lawyer, a distinguished judge, and a remarkable public servant. He was United States Attorney for the Eastern District of Missouri in 1960, United States District Judge from 1971 through 1973, United States Circuit Judge for the Eighth Circuit from 1973 until 1978, when he was appointed by President Carter to his present post as Director of the Federal Bureau of Investigation. It seems fitting in this audience that I should share with you a few more details of the remarkable career that we honor today and in the next 2 days. Judge Webster was born in St. Louis, Missouri in 1924. He is a graduate of Amherst College and Washington University School of Law in St. Louis. After a period of military service during which he was a member of the Air Force Judge Advocate General's Corps, the Navy Judge Advocate General's Corps, I'm sure he won't forgive that slip. He entered private law practice in St. Louis, enjoying not only success as a practitioner, but displaying the same kind of interest in public service that has characterized his career professionally since then. During that period, he chaired the American Bar Association section on corporation banking and business law, the largest section of the ABA, became a member and later a member of the Council of the American Law Institute, that distinguished body's governing board. In his relatively, by comparison with other judges, period of judicial service, he was the author of a number of widely regarded, much admired opinions. He earned praise from both the liberal community and from the conservative community, as well as, he would, I'm sure, confess, some criticism from both sides. 2 cases seem to me of note in this context. In one, he held that the federal prosecutors could lawfully invoke mail fraud laws against political operatives who had successfully deprived citizens of those intangible but essential rights, the right to an honest election. In another important case, he overturned the University of Missouri's refusal to recognize an organization of gay students, refusing to sanction what he termed the repression of ideas. It was his achievements both as a lawyer and as a judge that brought him to the attention of President Carter and to his then Attorney General Griffin Bell when a successor for Clarence Kelly as director of the Bureau was sought in 1978. You may recall, or at least some of us in this audience will recall, that that was a difficult era for the Bureau. It had been tarnished by the conduct of a former acting director during the Watergate period, severely damaged by charges that several investigators had violated the rights of members of certain controversial political organizations. President Carter sought someone whose integrity and energy and recognized commitment to vigorous law enforcement and protection of citizen rights could not be questioned. One Missouri congressman at the time remarked that Webster's appointment reminded him of the elevation of Judge Kennesaw Mountain Landis to be Commissioner of Baseball in 1920 following the Black Sox scandal. Judge Webster might indeed prefer to be Commissioner of Baseball sometimes, although I understand that job has been recently occupied by somebody with experience in the academic community. His real game is tennis, however. But we are all very, very fortunate that he is spending his full energies administering the Federal Bureau of Investigation, whose effectiveness in this complex era of computer theft, civil corruption, and international terrorism is essential, and whose efforts must be channeled so that they do not impinge upon individual rights. His is perhaps the prototypic impossible job. He enjoys, in addition to the recognition of his legal peers, the recognition of a number of prominent institutions of higher education. He has honorary degrees as well as awards from the University of Washington at St. Louis, where he also received the award in 1977 as its most distinguished alumnus, and honorary degrees from DePauw University, Washington University, Notre Dame, Centre College, American University, the University of Miami, and I rather suspect the one of which he is proudest, an honorary degree from Amherst College. On behalf of the law school and on behalf of the Student Legal Forum, it's a great pleasure to introduce Judge Webster today, who will talk on the subject of the lawful use of sensitive investigative techniques, and will, he's assured me, be pleased to answer questions at the conclusion of his prepared remarks. Judge Webster.
Thank you very much, Dean Merrill. I feel so good about such a lovely introduction. I think I should quit while I'm ahead, but I'm committed to be here, and I have been looking forward to this for a very long time. In April of this year, which was the normally scheduled time for the Thomas Jefferson Award, I did manage to make the lovely dinner at Monticello, which is be one of the highlights of my remembrances. But because the shooting incident in Miami, because of that, resulting in the death of 2 of our agents and the wounding of 5 others, it was necessary for me to leave the campus and go to attend the funeral there with a promise to come back and an offer to come back, which I deeply appreciated. And so here I am. That was, I think, a reminder that we live in a violent world, that we must take appropriate and lawful steps to protect our society and our individual citizens. And the challenge of law enforcement is to do it in a way that comports with the Constitution of the United States and meets all of the standards that an emerging society considers decent, fair, and appropriate. Well, earlier today was another highlight for me. 3 or 4 hours ago, 3 hours ago, in fact, I was attending the dedication of the Carter Library in Atlanta, where I heard a president who had defeated President Carter appear at the invitation of President Carter to participate in the dedication. It's hard for me to imagine many places in the world, especially in the Soviet or Soviet bloc countries, which only has one party, where such a condition could have existed. I sat with Judge Bell, who was the immediate past recipient of this award, and saw many of my former colleagues from an earlier era, including Judge Wade McCree, a former Solicitor General, in the audience. It marked a sense of continuum and a dedication to democratic principles that only history can truly evaluate, and which that library was designed to facilitate, not only for scholars, but for rank-and-file citizens who will be coming there to form their own judgments, not only about the presidency of President Carter, but also about the entire office of the presidency throughout its history. And as one who was appointed by one president and continued in office by his successor, I felt very good that the principle that the director of America's chief law enforcement agency should be, as his agency should be, above the political current, so that we could direct our efforts in ways that were not only lawful, but were perceived to be the objective use of lawful principles and not the political whim of the current chief executive. This has been kind of a momentous week and a momentous 2 or 3 weeks where we have seen the summit potentially in jeopardy because of incidents arising out of our enforcement of our responsibilities to protect the national security through the arrest of a KGB officer named Zakharov and the Soviet response by the arrest of Nicholas Danilov, a respected American journalist. Things have moved very rapidly, and as you know, Danilov is back. Zakharov, following his conviction, is gone, and a respected Soviet dissident, Yuri Orlov, and his wife will soon be coming to the United States. The President and Gorbachev have agreed to meet in Iceland. The summit goes on. Time will tell when all this is sorted out what it means in terms of international negotiations. But I can assure you that what it means in terms of our professional obligation to seek out and wherever possible, because when they are unprotected by diplomatic immunity, to arrest those who engage in hostile intelligence activities in this country will not change. I'm confident of that. Those activities perhaps should not be discussed in detail, at least until we are sure that the Soviet dissidents are safely back in free soil. So I turn instead to a less recent but still recent event in June 19th of this year, when Vladimir Makarovich Izmailov, the senior Soviet military attaché in the embassy in Washington, was arrested in a wooded glen out in St. George County, Maryland, outside Washington, D.C. He had just finished placing $8,000 in a drop site following picking up some material which had been furnished to him by an individual he thought he had recruited for hostile espionage activity in our country. He had previously paid that individual over $30,000 for information furnished with our knowledge and the cooperation of military authorities to make our case and develop the activities of the Soviet officer. $30,000 in addition to considerable spycraft equipment. Izmailov was expelled because he had diplomatic immunity. The person he thought he was working with was a double agent, an individual working for us, for the American government, and acting most courageously under very difficult circumstances in a scenario that could shift from moment to moment. helping us to identify, first to detect, then to identify, and then to penetrate the activity of the GRU, the Soviet military counterpart of the KGB. Much of this is going on in an endless struggle within the shadows of covert activity, and it's often difficult for us to explain in any significant detail the sources and methods that we use. Otherwise, they would not be usable in the future in this particular kind of activity. And the use of a double agent is a sensitive technique, as is the undercover agent and other sensitive techniques that we use. Increasingly in our society, and I look back over my notes 6 years ago when I spoke at the university about our three top priorities: foreign counterintelligence, white-collar crime, and organized crime. Increasingly, it is necessary for us to employ lawful but sensitive techniques in order to deal with these greater and more difficult crime problems. We now have a fourth priority, and of course you can guess what it is. It is terrorism. And again, we have found that these techniques have been indispensable in ferreting out, dealing with, and getting there first when acting against the terrorist menace. The informant, the court-authorized electronic surveillance, and the undercover agents are three of our most principal and most successful sensitive techniques. And I want to focus mainly upon those today. They're not secret. You have every right to know about them. They are carefully monitored, carefully managed, and we are accountable to legislative, executive, and judicial oversight. Some things are secret, and I'll stay away from those, and they deal with what we do in foreign counterintelligence. In fact, someone gave me a button not long ago that said, "My job is so secret, even I don't know what I'm doing." I hope you won't reach the same conclusion when I finish here today. But really, that's the test. How can these techniques be used to serve the ends of justice? Throughout our history, there has been a legitimate tension, one that the law students here will readily recognize in their cases, in criminal law and constitutional law especially, where on the one hand there are those who are demanding the cherished right to be let alone. Not left alone as so many people write, but let alone. A constitutionally endorsed principle. And on the other hand, whenever we have an outbreak of terrorist activity or skyjacking or major drug enterprises or organized crime rampant and unchecked, there is a legitimate demand to do something about it. It's society's demand to be kept safe and free. Between these two cherished values lies a tension with law enforcement squarely in the middle. It is a balancing process, as is so much of life and law and experience as we understand it today, and it is one that falls heavily on the law enforcement community. And there's an emerging standard through the years, sometimes more conservative and sometimes more liberal, if you want to use those terms, depending upon conditions in society and the need for tightening belts, or when the need is not there, for loosening belts to provide more individual freedom. It wasn't too many years ago that I had occasion to write an opinion about the use of the inspection points in aircraft terminals. Those things you go through where you either have your baggage checked manually or through an electronic or X-ray process. It's really difficult to talk about it in the terms that we were thinking about a decade ago. I believe that's when it was written. Whether or not that was so intrusive as to require that they be set aside, or on the other hand, whether the nature of them was such that someone passing through them was exonerated from statutes making it unlawful to carry weapons aboard aircraft on the theory that they had tendered themselves up by going through the detection devices, and therefore, if they weren't caught, they could not be found guilty of having criminal intent. The ruling of the opinion was that it was a no-intent statute, not requiring criminal intent, merely requiring knowledge of what was taking place. And in the course of that opinion, I had occasion to speculate that given the circumstances and given of individuals carrying weapons on airplanes and the number of hostage takings, airplane skyjackings that were going on in those days, if you remember largely the rush to Cuba, that most Americans were willing to permit this minimally intrusive technique in order to assure their safety aboard aircraft. And I speculated that if they were suddenly withdrawn from the airports, there would be a hue and cry of outrage, legitimate outrage, that those of us who were passengers on airplanes were not being protected. Today, that's viewed as minimally intrusive. But I want to talk about some techniques that are perhaps more than minimally intrusive, but nevertheless meet all lawful constitutional standards and are entirely, in my view, appropriate when we are dealing with tough criminal problems that cannot be otherwise addressed. We have found extraordinary value in detecting and investigating, and in some cases, preventing the activities of spies, of terrorists, of organized crime figures, of drug traffickers, and of corrupt public officials. I might say, incidentally, in looking back over our history and experience with using these techniques in all of those areas, there is almost uniform public support for our use of those techniques in areas where violence is associated. There tends to be considerable public support for our use in public corruption cases, but as you might well speculate, there is considerable criticism from those others in public office who think that somehow we may be trying to set them up or go after targets for particular political reasons, either because they are opponents of the incumbent president or for some other reason. And therefore, it's extremely important that we be able to demonstrate the objectivity, the impartiality with which we approach the problems of corruption in office and the use of sensitive techniques to deal with them. I think the key to the use of these techniques, and I don't have to go into a lot of detail about what the courts have said about them, they are lawful. The key is in pre-established rules of conduct, in place and understood by those of us charged with law enforcement, and ultimate public accountability. The knowledge that what we did and how we did it will be reviewed both by the Department of Justice, by congressional committees, and in the courts. We have in place, with respect to all of those techniques, that's the informant, the undercover agent, and electronic surveillance, guidelines established by the Attorney General of the United States. We've worked with the Attorney General in establishing those guidelines. The FBI has never been afraid to be regulated. In fact, we welcome the opportunity to know the parameters in order that I can assure our agents that when they do their job, they can do their ultimate job and not 6 steps behind where they ought to be on the front line of a difficult law enforcement program, because they will be protected from unjustified litigation, criminal prosecution, or discipline. In addition to the guidelines imposed by the Attorney General, we have additional rules within the Bureau that are policy matters that I have put in place that are in some areas are more stringent than those required by the Attorney General. And we have accepted the duty of public accountability and are prepared in the proper forum to respond to questions and criticism from the Congress and from the press. Let me talk about those three techniques and show you how we manage, as I've just described. Now, there are many kinds of informants. We still consider them to be the single most important tool in law enforcement. If a bank robbery is not solved within 48 hours, it's just not going to be solved unless someone comes forward and gives information. We go to the crime scene, we do the forensics, we take eyewitness statements. If we don't have an identity, we're going to be in difficult condition without a solid informant base that will help us eventually find the persons responsible. Informants may run the whole spectrum from corrupt criminals seeking to better their lot in a particular condition in which they find themselves, to get a shorter sentence, to get a sentence commuted, to have the number of counts reduced in a pending criminal trial, a whole range of reasons why a criminal may decide to cooperate with us. And we do accept that cooperation, knowing the risks that go with them. They are there. They know the facts. They have the leads. It's a little like asking our agent. Years ago, our agents used to go into bars, and because they weren't allowed to drink, if they were trying to get information, they ordered a glass of milk. You know, there wasn't very much cover to their activity in those days. But the information we receive from informants can be very, very useful to us. They're not all crooks. Jimmy Fratiano is probably the ultimate crook informant, who, for reasons of his own, pretty good reason, he found out that one of the top leaders of one of the top La Cosa Nostra groups had put out a contract on his life, decided to cooperate with us in return for protection. That's a good enough reason. Through Jimmy Fratiano, we have had numerous convictions, an extremely important intelligence base to understand the apparatus, the techniques, the skills, even the rituals of the traditional mafia groups. And because of that basic understanding, and through other efforts over several years, you are now reading about all of the top players in all of the top families standing trial in New York City. He's been helpful in other cases that have literally eliminated the leadership in a number of key cities. Now, that's a subject for another discussion or questions and answers. But I simply point out that this crook has been an important asset to the country through his cooperation with the FBI. Taking at the other extreme, we have many good citizens who want nothing more than to see a bad situation cleaned up. Judge Brockton Lockwood is a good example of that. A state circuit judge on loan from his court in Springfield and serving as a judge in Cook County, Illinois, an area where every lawyer knew that there was pervasive corruption within the judiciary. This is not a secret in Chicago alone. It was widely known throughout the United States, yet for 2 decades, no one had attempted to deal with the problem. He offered his services. A number of other people, who I don't have time to describe, offered their services. And because of the information that was given to him, because he was immediately assumed to be part of the fraternity of accepting bribes and fixing cases, he was able to give us substantial information. He carried a tape. He was considered to be kind of a country hick, and so he carried a tape recorder in the boot of his cowboy, in the heel of his cowboy boots, and gathered considerable information for us, which is now working in a case called the Greylord investigation, one of the most significant and important cases during my tenure as Director of the FBI. There have been 56 indictments in that case, and already over 36 convictions with only 2 acquittals, and the pending cases will be tried or result in pleas of guilty. Very substantial good coming from the cooperation of a good citizen. I could tell you about other good citizens, such as Lou Peters on the West Coast, who, even though terminally ill, served with us for 2 years, in an undercover operation that led to the conviction of Joe Bonanno Sr., someone the authorities had not been able to reach for half a century. These informants are often, unlike the ones who appear as witnesses, often require confidentiality, and we're willing to give it. Now, this means that we've got to keep very careful records of what they do, what we pay them, what we have told them, and we must supervise their activities very, very carefully. They're told that if they commit an unauthorized illegal act, and I'll come back to that we will not protect them and that they will be prosecuted. In order to protect their credibility inside an organization, and in order for us to reach beyond the streets up into the upper echelons of criminal enterprises, it's often necessary for us to allow such a confidential informant to engage in minor, nonviolent criminal activity in order to preserve that credibility. We have to know what it is. We have to know how it's being done. It usually involves carrying the bag for somebody else. But we keep records of it. It's carefully approved at a supervisory level. And if there's any variation from that, the informant is subject to prosecution. We are unlike a number of other law enforcement agencies that tolerate the so-called hip pocket informant, where to protect the informant, no records are kept. Obviously, we must keep records if we're going to be accountable to appropriate oversight in the Congress and in the Department. And so the answer to that is to keep careful records and then keep the records carefully. And our informant records are kept very safely in each of our field offices. And strict adherence to the Attorney General guidelines for the use of informants closes the management loop and gives us confidence that we are proceeding with these informants in a lawful way. Electronic surveillance, and usually I'm very careful to say court-authorized electronic surveillance, and I won't keep saying it that way, but you consider that that is what we're talking about, is perhaps the most sensitive of all the techniques, and the one that we use most frequently to produce the best results. Let me say categorically that the FBI does not tap the telephone lines of any individual under any circumstances without a court order. Even in the case of espionage activities, we go to a special court created under the Foreign Intelligence Surveillance Act for permission to put the electronic surveillance in place. That's also true of court-authorized microphone surveillance. It is not true of consensual telephone conversations because there is no privacy, expectation of privacy between two individuals speaking on the telephone if one of those individuals wants to make a recording or allow anyone else to listen to that conversation. But in the case of incidents where two people are talking and neither of them have consented to an overhear, we always have a court order on a showing of probable cause. In one instance, and we're very careful to have strict observance of the law as it exists in any particular circuit. In one instance, we had a case where the Sixth Circuit out in Cincinnati ruled that there was, although the Title III in the Omnibus Safe Streets Crime Act of 1968 had authorized the procedure for electronic surveillance, and for electronic microphone surveillance, it had not provided for a surreptitious entry into the place in order to put the microphone in place. And therefore, it could not be done surreptitiously. If you're thinking what I am, that means you knock on the door and say, "Sir, may I please put a court-authorized microphone somewhere in your room?" Well, of course that wasn't going to work, and we immediately appealed it. But in the meantime, we shut down every activity of that kind within the Sixth Circuit. Shortly after that, the Ninth Circuit came down with a similar ruling, and we shut down everything on the West Coast. Fortunately, another case was percolating up through the system, the Dahlia case in Judge Lacey's court in New Jersey, which went to the Third Circuit and then to the Supreme Court, and the Supreme Court held that the right to make a surreptitious entry in order to place a microphone in place that had been authorized by a federal judge on a showing of probable cause was inherent in the statute, and it was not necessary even to say so in the application for the warrant. So we reinstated, of course, the activity in the Sixth and Ninth Circuit. But I sent out an instruction to all our field offices that notwithstanding the Supreme Court's opinion, we would continue to reflect in our application for a court-authorized microphone the fact that it would be necessary to make a surreptitious entry in order to use it. I believe then, I believe now, that it is well for the district judge to know all of the facts on which to make a decision, and that we will be better off if no one ever believes that they have been misled in any of our applications. And I believe that was the proper way to go, even though it's more restrictive than the Supreme Court requires. Well, I can give you one example of where electronic surveillance was extremely useful to us, although there are legion. The organized crime figures, while they rarely meet, continue to talk on the telephones. They have to talk on the telephone. I remember in the Brylab cases involving Carlos Marcellos, who was convicted ultimately, in one of the conversations they were talking about the conviction of Joe Bonanno, which involved some electronic surveillance, and Carlos Marcellos is saying he should be more careful. The same telephone convicted Carlos Marcellos. So we use it. It's important. We use it not just for organized crime. We use it in terrorist cases. We use it, of course, in foreign counterintelligence. And wherever it's appropriate, we use it in white-collar crime. We satisfy ourselves first that there's no other way of doing it. We've tried all the traditional investigative techniques. It isn't something we run out and do. Not only because of the civil liberties involved, but it is, as a practical matter, it's expensive and time-consuming, labor-intensive, and we should not use it unless we absolutely need to do so. When we do it, we must also tell the court how we're going to minimize the use of that technique. I want to start to tell you about one of the cases, the case of Anthony Scotto, one of the most popular labor figures in the New York City area. A few years ago, we ran a major investigation involving over 100 agents working full-time for over a year, all along the East Coast, trying to deal with the problem of corruption on the waterfront, corruption that was increasing the cost to the ultimate consumer, corruption between warehousemen, between shippers, and labor racketeers. Scotto was the principal labor figure in New York, and he was indicted. He brought into the courtroom a former governor and a former mayor to testify to his high character. There isn't any doubt in my mind that his personal appearance and demeanor, the character testimony that he gave, would have had a tremendous impact upon the jury had we not played the tapes. The actual transaction being played before the jury, they could hear all of the venality, could tell with certainty what actually happened. We could have had Scotto saying it didn't happen at all, or it didn't happen that way, it happened this way, but the tapes were absolutely proof positive of what had taken place, and of course he was convicted. Interestingly enough, our rules on the use of electronic surveillance vary substantially with most of the European countries, including Great Britain, where everyone does it without a court-authorized warrant, with the authorization of the minister, usually the Minister of Interior. And when the evidence starts to come in, they know that it must have been derived from a tape, an intercept, but no one ever makes reference to it. In my view, our way is much the better, because we have conspiracy laws in this country, and what's taking place before the jury is the crime itself. not some other evidence derived from a secretly authorized by executive side, not a neutral magistrate, secretly authorized intercept. In any event, that's how we use it, and I'm really confident that we're doing it well. Minimization procedures protect innocent third parties and even suspects from having us intrude too deeply into their private lives. We turn off these machines whenever it appears that the subject does not relate to a criminal subject, or if someone who is not a suspect gets on the machine. We usually, when we can, have someone observing a public telephone booth, and they're very popular places for criminals to go to make criminal conversations. And only when the right person goes in the telephone booth, then we then radio in and the lines are started up. There's a great deal of effort made to protect innocent citizens from the effect of such intrusive activity. Well, I suppose the most romantic of all of the three is the undercover agent. Some people are terribly afraid of undercover activity. Some people think it's the greatest thing since Swiss cheese. It's probably somewhere in between. It's a technique that we use with increasing effectiveness to deal with consensual crimes, where you have willing participants on both sides. It's not like a bank robbery, but where you have bribery, prostitution, which is not really our concern, but when you have, I'm illustrating, bribery, prostitution, gambling, and public corruption. You have a bribe taker and a bribe receiver, or a bribe extortion and a bribe payer. And you have people who are doing that because they want something accomplished. You need something to prove that this activity is taking place. And you're not apt to get it from either of the two participants, and they're not apt to do it in the middle of Main Street. But where we have clear evidence or indications that this type of criminal activity is taking place, and you can't do it pervasively for long before other people get wind of the fact that they're not getting that government contract, or that certain kinds of cases are being fixed in court, or other forms of corruption of that nature. We're then in a position to use the undercover agent to simply act out what everyone else is doing. We may set up a company to try to do business with a county that has corrupt county commissioners in it, and they do nothing more than anyone else has done. We're very mindful of the problems of entrapment, and we can talk about that now or during the question period. But we must have predication before we do it. We must not engage in entrapping activities, and our agents are taught to avoid entrapment. Nevertheless, they're there, and they provide the opportunity for the corrupt official to do what he has been doing with other people. And when he does it, we have evidence of what he does. That is, in general, is the kind of activity that we use in public corruption cases. There are other kinds of cases where they're used. We had two important cases involving conspiracies to assassinate major foreign officials. One, President Suezo of Honduras, where we let an undercover agent act as the hitman they were trying to employ. They brought $11 million worth of cocaine into this country in order to finance this operation. It was a serious undertaking. Similarly, an undercover agent acted as a paramilitary expert in order to train Sikhs who wanted to assassinate Prime Minister Gandhi, and were able to develop information about the nature of the conspiracy, the size of the conspiracy, and to bring everyone known to be involved into the indictment. That undercover agent, incidentally, had previously served as a paratrooper, had lost his eye in Vietnam, had received the Congressional Medal of Honor, had requalified as a paratrooper, and then asked to join the FBI. I had to overrule everybody because of the eye problem, but I said he's earned the right to train. If he can pass his training at Quantico, he deserves to be a special agent. He's been an extraordinarily successful agent, not only because he's good and courageous, he's on our hostage rescue team, but because in undercover operations, nobody believes that somebody with one eye is apt to be a special agent of the FBI. And that's worked out well for us. Well, I could go on and on telling sea stories about these techniques, but what I really want to say is summed up in something that Justice Robert Jackson once observed, that the Constitutional Bill of Rights of the United States was not a suicide pact. The protection that it affords must be rationally applied. We know that if we are to prevail against those who would frustrate by their violence and their lawlessness the liberties our Constitution was designed to secure for us. And our lawful, if occasionally intrusive techniques can, with proper management and oversight, protect our citizens and our nation from the power and viciousness of criminality that would otherwise thrive unchecked. By following closely our statutes, our guidelines, our rules, and our regulations, by accepting legitimate executive, congressional, and judicial oversight, by striving for fairness, and by seeking always to balance the concerns of liberty and order, we can, and I believe that we do, truly serve the ends of justice. Thank you. Just take them, if that's all right. Now is the time for questions. If I can't answer or won't answer, I'll tell you. But otherwise, I'd be glad to try, and on any subject that is of interest to you. Yes, sir.
I was just curious what you think about the idea that original intent should be used to interpret the Constitution, and how we can apply original intent to these type of surveillance problems when the framers probably didn't have any concept of these type of issues?
I question, I said if I can or if I won't. That's one where I shouldn't. But there's difficulty getting into semantics about this. They're becoming conservative liberal buzzwords. And I think that what one must first do is see what the framers of the Constitution said, knowing that they didn't have any way of anticipating the growth of technological capability, the way our society would emerge as an industrial society, population changes, new challenges to our moral fiber, such as incursion of drugs and so on. Having looked at what they required, such as a search warrant, there really is no difficulty in my mind in coming to a conclusion that a search warrant should be required, is required, and should be applied for wherever it's reasonably possible to obtain one, and that nothing in our society has changed that. One may argue about what is an exigent circumstance. One may argue about the difference between an automobile and other forms of circumstances where searches are involved, but nevertheless you come back to the basic principle that that if it's possible to get a search warrant, reasonably possible, and I've used the word reasonable because the word reasonable appears in connection with search warrants, that you should do so. One of the examples that I had intended to mention to you was in connection with our investigation of a vicious terrorist group operating primarily in the Chicago area, but actually nationwide, called the FALN, a Puerto Rican independence movement that was responsible for a great many of the statistics on terrorism of the last several years. We had arrested a group of them in Evanston, Illinois, 6 or 7 years ago. A good citizen had wondered why so many people standing beside a van in jogging clothes were smoking, and called the police. As a result of that good citizen and good police work and prompt notification of the FBI, just within hours we had located safe houses in Milwaukee and New Jersey and wrapped up their 10 leading figures. They went dead for a while, And then after a few years, they came back, began to plot to see if they could extricate their leaders from Leavenworth and other penitentiaries and engage in other types of criminal activity, terrorist activity, which might force their release. They began to gather explosives and weapons in safe houses, one safe house in particular, which we were able to identify, and we put into place a closed-circuit television under court order. We watched them. We had terrible trouble understanding them. Not only did they speak Portuguese, rather Puerto Rican, but they spoke in code about what they were doing, and we could not really figure it out. So we got the order to put the closed-circuit television in place, and we could watch them. And from watching them and listening to them, we could detect what their plans were and what their objectives were. It also permitted us later to come back surreptitiously and defuse a good deal of what they had been working so hard on to minimize the risk to third parties. In their trial, they challenged our right to put in a closed-circuit TV. And in the course of the trial, Judge Posner in the Seventh Circuit simply concluded that there is no right to be let alone in safe houses. I think that kind of thinking probably would be consistent with the reasonableness approach implicit in what the original founders had to say. That's the best answer I can give you. Yes, sir.
Sir, many of us, I feel, need to be grateful to the few law enforcement officers, including the FBI, for they are always putting their lives in line of duty. They get shot and they make headlines for a day and then we forget about them. My question is twofold. One, in Virginia, you have a Virginia Star Foundation to help the Virginia State Troopers' families and the children. Whether you have any program like that for the FBI agents. And the second is, since the officers undergo through a lot of stressful situations day to day, and being a physician, I get to see some of the officers and their families. Is there any provision for some kind of counseling program for them to handle it?
The question has to do with what we in the FBI and others do to deal with the consequences of stress, injury, and death to law enforcement officers. We do quite a bit, but I'm convinced we'll never do enough. In the FBI, there are strong programs, insurance, and benefits that are very, very helpful to the surviving members of an agent's family when an agent is killed in line of duty. We're very fortunate that the numbers of agents killed has been relatively small, but every year there have been already over 80 state law enforcement officers killed this year in various parts of the country. In most major cities, there are organizations called Backstoppers, 100 clubs, 200 clubs, Heroes, an organization of good private citizens who undertake on their own behalf to raise substantial amounts of money to take care of the widows and orphans and to assure in good programs that the children of such agents or police officers are properly educated in the future. There may even be some in this room. That, again, is great. It's great because the police officer knows that his community cares about him when he puts his life on the line. In addition to death, of course, is the problem of stress and the enormous impact that comes. I have a special exercise, a post-shooting incident, in which all of the activities in any shooting incident, even if no one is hurt, is carefully reviewed, including the stress on the individual agents. We're looking for ways to improve our discipline and our procedures and our tactics to minimize those risks for the future, but also to know best how to deal with the agents who are feeling the effect of stress after a shooting incident. I think we probably have the most disciplined and most all-round kind of people able to cope, culpable people, if there's such a word, anywhere in the world, and still they feel the stress, even those who didn't actually shoot. And we have two professionals who happen to be husband and wife who were resident in Philadelphia on full-time consultation to us. They're ready to meet with participants in a shooting incident, to talk to them and counsel with them on the phone. They talk to widows, they talk to children, they talk to the agents who were injured or the agents who were in a shooting incident. to help guide them, and they talk to us to the extent that principles of confidentiality permit them to talk to us on how to deal with particular people who might be having problems. I think that's the least we can do, and I think I'd like to know of other things that we could do to help them. Yes, sir.
There have been several highly publicized cases recently, scam, ab scam type things, where the FBI has used the services of people who weren't special agents, but who were some, I don't know if they actually had criminal records, but there were some, shady people.
Right.
And the defense lawyers in these trials that used, with some success, arguments that, how can you believe this person, and do you continue to use that system?
That's a very good question, and it's one I should have covered in my remarks. A confidential informant is just that until he is willing to give testimony. Then we call him a cooperating witness. So it's often one who we know will have to be a witness in the trial. We call them cooperating witness because they're part of the investigative activity, even though they're participating in the scenario, usually in their own name and who they are, but they're not telling their buddies that the FBI is involved as well. It's very risky because they're not born again. They're working with us for some reason, but it isn't because they've been born again, and we know that. So it requires very careful management of them. And one of the principles that we've learned as a result of some of the experiences, even though we prevailed in the courts, but we took enough heat and enough questions to anticipate the problem in the future. One of the lessons is we must minimize the role of a cooperating witness as soon as possible. These fellows vouch for our undercover agents. In Abscam, we never would have gotten in without the cooperating witness who knew the con men and the crooks and the corrupt political figures and the other middlemen who were involved. And that is true in many, many situations where they vouch for us until our agents are able to function in this crooked environment. We know that if our agents can be the ones to testify as to the payment of a bribe or a political criminal activity that they personally observe, the jurors will generally believe them, where they will not believe a cooperating witness unless they're forced to. If you have a judge, and that's how we lost the one judge in Chicago. It was the only case in which the cooperating witness made the payment rather than special agents of the FBI. You have a nice-looking person with no previous record, and you've got a crook who's known to be a crook and whose record comes out in the trial. The average juror is going to want to believe the person who's presumed to be innocent, and that's fair, and that's the way it should be. So we have to corroborate that kind of evidence with other evidence that is so compelling that the jury must believe that that crook that they don't like is nevertheless telling the truth, and that that nice guy that they like has engaged in criminal activity. And it's better if we can get rid of that confidential or that cooperating witness as soon as possible. And in the past, we've made, I'll be frank to admit, we've made some mistakes because we were afraid if we let him loose and said, thanks, fellow, we don't need you anymore, that he'd go back to doing some criminal activity that would in turn disqualify him as a witness later on. And they've kept him around to keep him from out of trouble. We found some other ways to deal with that problem, and we're dealing with it. I don't like to use cooperating witness beyond that point, that threshold point. There's a case I don't like to talk about because I had an unsatisfactory result. It wasn't my favorite case to begin with. I knew it was going to be an enormous waste of our resources in terms of the trial, and that was the DeLorean case. The conviction of DeLorean would not have changed the amount of drugs being brought into this country. It had nothing to do with that. The FBI was investigating a drug ring. We got the evidence on the drug ring, and the United States Attorney wanted to match DEA's investigation of DeLorean by putting the two of them together, which he did, with the result that when DeLorean was tried, they were so infatuated with television tapes of him running his hand in cocaine and saying better than gold, that they had not addressed the fairness issue that I mentioned earlier in my talk. The fairness issue. Was this fellow set up? Now, that's not entrapment, but was he set up? Was he vulnerable? Did Hoffman, the DEA confidential or cooperating witness, make the pitch? Was he out bounty hunting? Or, as Hoffman said, did DeLorean, in his conversation with him, bring up the subject of drugs, and remembering that Hoffman had been in drugs, ask him if he could give him a hand? Now, the answer to that would have been, in 20/20 hindsight, for the investigators and the prosecutors to have arranged during these carefully filmed conversations for Hoffman to have turned to DeLorean and said, "Boy, you could have knocked me over with a feather when you came up with that idea. What made you think I could pull off something like this with the cocaine out in front of him?" Chances are pretty good, if Hoffman's story was true, and we thought it was, that DeLorean would have said, "Well, I knew this, and I knew that," and so on. So then after that, the jury wouldn't have to deal with the problem of a man with no criminal record saying it happened one way and a crook saying it happened another way. We also know that these fellows can dirty up a case if we don't know everything about them. But they are essential in these consensual crimes to get inside the operation. We cannot penetrate many of these operations unless we have a seeing-eye dog who takes us in and shows us how it works, and at least gives us the introduction so we can go on our own. Yes?
Currently, DEA and FBI agents train together at Quantico.
Mm-hmm.
I'm wondering, from the rumors that I've heard, is it true that the DEA can merge with the FBI?
Question has to do with possible merger of FBI and DEA. You know, of course, that at our training academy at Quantico, we enjoy cross-accreditation privileges with the University of Virginia, which we're very proud, and that many of your professors, such as Professor Lowe, have given us extraordinary help on the legal side. The future of FBI and DEA is still unclear to me. When I was given this responsibility in 1982, the FBI was brought into drugs for the very first time. We'd not been in the drug business. There had been some apprehension by previous directors about our getting into drugs and what it could do to our agents. But when I realized it was the #1 problem in the country, #1 crime problem, why, I supported it fully, as did, I think, most of our agents. The DEA, the Drug Enforcement Administration, was directed to, and at least gives us the introduction so we can go on our own. Yes?
Currently, DEA and FBI agents train together at Quantico.
Mm-hmm.
I'm wondering, from the rumors that I've heard, is it true that the DEA can merge with the FBI?
Question has to do with possible merger of FBI and DEA. You know, of course, that at our training academy at Quantico, we enjoy cross-accreditation privileges with the University of Virginia, which we're very proud, and that many of your professors, such as Professor Lowe, have given us extraordinary help on the legal side. The future of FBI and DEA is still unclear to me. When I was given this responsibility in 1982, the FBI was brought into drugs for the very first time. We'd not been in the drug business. There had been some apprehension by previous directors about our getting into drugs and what it could do to our agents. But when I realized it was the #1 problem in the country, #1 crime problem, why, I supported it fully, as did, I think, most of our agents. The DEA, the Drug Enforcement Administration, was directed to report through the Director of the FBI to the Attorney General, giving me some authority then to direct and develop a national strategy between the two agencies. We began to do a series of things, including bringing the DEA agents into Quantico for training. It was like taking 2 water skiers behind the boat and bringing them together, and that's worked very well. In the previous history, and I recall my days under Eisenhower, as United States Attorney, trying to cope with the reorganizations of the Drug Enforcement Administration. Every new agency would reorganize. It would be the Bureau of Narcotics, and the Bureau of Narcotics and Dangerous Drugs, and then the Drug Enforcement Administration, back and forth between the Treasury and the Justice Department. And they were shell-shocked. The one thing they didn't need at that time was another reorganization. And if we were going to get in and be effective, we had to do it without inertia gaps or loss of momentum or reduction in morale. So I treated them as full partners in the operation. Now we're at a point where we realize and have been directed to find ways in which we can further integrate And we have done a number of things that have not been widely publicized, but we will be going to a common communication system with digital voice privacy that will permit them to talk to themselves and us to talk to ourselves and us to talk to each other. We have 900 joint operations going, joint task forces working. We've got to be able to work with each other. And the Marshal Service will probably be brought into that communication system. We're trying to develop an all-source intelligence center between which will involve not only the two agencies but all the Coast Guard and the Customs and IRS and INS and all the others. I haven't answered your question because I don't know the answer to the question. What I've said was the one thing I didn't want to do would be have to undo anything that we'd done. Every step has been carefully thought through, been put in place, and has succeeded. If at any time someone say no, DEA will not merge with FBI, nothing that we're doing now will harm that decision. On the other hand, if the decision is, as I think it's going to be, integrate further, we will do it. We're going to require some ratcheting because, you know, they're both proud organizations and there's always a little bit of resistance. But we've been co-locating DEA with FBI. We've had all those joint task forces working together. I have FBI executives in DEA, and there are DEA executives in FBI. All the things that make a marriage possible are taking place, and the result has been remarkable. We found we actually like each other. That's something nobody thought would ever take place. Yes?
Yeah, what resources must the Bureau spend to maintain adequate surveillance of foreign intelligence agents operating in the U.S., whether they be from Soviet bloc or from our own allies? What is the expenditure in comparison to what it was today, to what it was when we came into office? And what sort of drain does that represent in relation to other Bureau activities like organized crime?
That's the financial and other impact on FCI on our other work. We have been getting additional resources for the last 5 years. President Reagan has supported this effort by directing what they call out-year increments. In other words, he not only decided to increase it in 1 year, but he said it would be increased at that level every year in subsequent years. And he's stayed with that. So we've been getting additional resources as we've applied additional manpower to the effort. And that's been an important contribution at a time when the Soviets, the Soviet bloc countries, and third world countries have been getting increasingly aggressive in hostile intelligence activity in the United States. I can't give you the figures because they're classified. It represents a significant percentage of what we do. It's one of our 4 top priorities. Nothing is more important. You know, there's all this terrible fear about terrorism around the world and terrorism in the United States. But we've driven terrorism down statistically in this country. We're averaging 100 terrorist incidents a year when I took over. And without going into all the how we did it and how it happened and why it happened, it went down to 51 and then to 52 and then to 31 and then to 13. Last year there were 7. This year, there's only been 1 confirmed incident, although the recent bombs that were found up in Corleal, Idaho, may count as a terrorist incident. But it's very, very low in this country. A major problem around the world because our people are getting hit. American citizens account for and property for 40% of the world's terrorist incidents. And I just left 2 days with the Italian authorities dealing with our arrangements with them. So there's terrorism. The reality of it is, in this country, it's very low. The fear of it is very great. Somehow, the reverse is true of foreign counterintelligence. The fear of it is very low. The reality of it is very great. And I am always pleased when the President is willing to announce that there's going to be a reduction in the Soviet presence at the United Nations. That sanctuary houses about spies and an incredible amount. 30 to 40% of all the diplomats that they send over here have intelligence responsibilities. And the assumption is that we will match agent for agent, but you don't match agent for agent. Keeping track of one known hostile intelligence officer 24 hours a day takes more agents than I would like to tell you, especially if we don't want them to know who our agents are. You know, they're trained too. They can recognize surveillance techniques. And we have agents that are changing places, and they move down the street where we've got agents in different spots. We have people up in the airplanes watching them with the modern technology. It takes a lot of people to keep track of one of them. And when one of them goes home, because the numbers have been reduced, I send up a little cheer. It isn't a question of being unfair to them. They have about a third more people over here than we have over there. So it's just reaching the principle of reciprocity and equivalency and making the best use of the financial resources that are available to us. It would have its advantages. Yes, sir.
What do you think is the proper role of the military in combating narcotic trafficking?
I think we're in a period now when drugs have become a great political issue. And the congressmen are all up for re-election. They've been home and they've been listening to their constituents. And they've been coming back to Congress with bill after bill after bill. Some bills good, some bills not so good. And I have to be careful about saying that because we appreciate all the help we can get, but we also know that we're going to have to live with bad legislation. And one of the most sensitive areas is the proper role of the military. For years, we have had the principle of posse comitatus, which is a statute that says the military shall not engage in law enforcement activities within the confines of the United States, except, of course, to police their own military reservations. That law was amended a few years ago to permit assistance in drug trafficking situations. The assistance is to be along the border and out into the waters as drug traffickers come by air and by sea. And they have been tremendously helpful to us in using the balloons, the AWACS. It was a little slow at first. The Army wasn't sure about all that. They lent us their first AWAC. It was up one day and sent us a bill for $600,000. And we said, no, it doesn't work that way. Everybody pays their own way. And since that time, they've been successful. The Navy really is beginning to like it because there aren't too many sailors that have ever had to fire guns in anger, and that's good training for them to help the Coast Guard, even though the Coast Guard usually goes on the military, on the ships and makes the arrests. All the intelligence, all of the help that we can get in interdicting the inflow of drugs at our borders would be very useful, helpful, and in my opinion, appropriate. Any other effort to involve the military in a law enforcement initiatives, investigations, arrests, interviews, tracking down, and so on, I think implicates the military in our lives and in domestic order in ways not contemplated by our founding fathers and not in our best interests. We are not in that kind of crisis, and we build a crisis of our own if we start sending people who are not trained, who are not law trained, in to do this work. All the intelligence and help on the edge, gratefully received. Inside, I'd rather see them stay outside.
Well, there have been so many terrorist incidents recently around the world. It almost seems as if somebody's maybe perhaps masterminding this or behind it. Do you have any thoughts on whether it might be the Soviet Union?
I do not subscribe to the monolithic theory. We can never rule it out, but there's no need for it. Even Claire Sterling, who's written perhaps more on this subject as a civilian and a very conservative one at that, does not believe that the Soviets, that all roads lead to Moscow. They don't have to, as long as they've got friendly countries like Libya and Cuba engaging in these types of surrogate activity. They don't have to do anything at all anymore. Years ago, they were probably facilitating certain types of activities that created instability in countries where it was to their advantage to see instability, furnishing of weapons, some training, and so on. I simply do not see evidence, solid evidence, You'll have those who will disagree with me say, well, just because you don't see it doesn't mean it's not there. And I accept that premise. But you ask, what do we think on the basis of what we know? And I do not see that. There are all kinds of terrorist activity around the world, and even in this country. You've got your far right and your far left. You've got your Covenant Sword and the Arm of the Law, the Aryan Nations, the Order, Posse Comitatus groups on the right, and until recently the Armed Forces Resistance Unit, the United Freedom Front, and other left-wing organizations operating on the left, as well as the Puerto Rican independence movement, which was very, very active. And then we had certain international terrorist groups, the Armenians going after the Turks, the Sikhs going after Indian officials, groups of that kind, Croatians objecting to Yugoslav policy. Most of that has been wrapped up by very good intelligence, and we prevented 23 incidents from taking place last year, which is an important key and one of the reasons why undercover work and electronic surveillance can be so useful to us. But in all that intelligence, we saw nothing that suggested that the Soviets were responsible for it. The problems in France are Middle East problems. I can see no connection with the Soviets at all. It's true, you can look at the top players and say relationship of Soviet to Syria and so on. But there's these groups, these Palestinian groups, for instance, often are at war with each other, so that there isn't any simple answer to it. France is reaping the whirlwind from years of sanctuary principles where if you leave us alone, you're welcome to stay here. And the first time they decided to get tough on somebody, the terrorists began to create an uproar in France, and they'll have to deal with that themselves. We're coming now, Attorney General and I went to The Hague in April and met with the Trevi Group, the Ministers of Interior and Justice for the European Economic Community, in an effort to get them, and I think we did, get them to agree to share intelligence, to work from multilateral sharing rather than from bilateral sharing. That was shortly after the Libyan exercise, and you wouldn't believe the different assessments of the Libyan threat that existed in the various countries of Europe. And as it developed, they began to see a change in Libyan policy from merely picking on their own dissidents to beginning to look for high casualty incidents in other parts of the world and against non-Libyans. And the reaction was immediate. The countries began to reduce the Libyan presence, began to take appropriate steps. In none of that do we see a common denominator. That is, in the Libyan we have a common denominator, but in the various terrorist activities that are taking place, there is no single thread that says it all comes from one place. And while it would be nice from a political polemic for those who hate communism and hate Russia, and I'm not a big fancier myself, but I think for those of us who are trying to find facts and truth upon which to base good strategies, we can't be misled or beguiled into simplistic solutions that are not supported by the evidence, because it won't stop the terrorism, and it might get us into war if we don't know what we're doing. Yes?
One question about the Danilov case. Seeing Zakharov waltz down the Jersey Turnpike yesterday and the circus of cameras and everything, and then leave the country, and in the wake of a lot of speculation that you might be somewhat stymied now with fear that after months of effort you pick someone up and the Soviets could immediately pull what they did with Danilov. Isn't it very frustrating to have this sort of thing happen?
Well, it is frustrating, and I took pains at the beginning of my talk to try to make the point that we do not consider ourselves stymied, that we will continue to function just as we have in the past. There was some confusion at first by those who saw it happening and said, why at this time did you do this? Was the FBI going flat-footed all over the summit preparations, and were we off on a frolic of our own creating trouble? This clearly was not the case, but it was advanced by columnists who well, I don't know political characteristics, but columnists who were very anxious to see the summit take place under any circumstances. This investigation, as are most of our investigations, not all of our investigations, are carefully coordinated with the other agencies of government. We advise the State Department of what's happening, the likelihood that we will have a criminal case, an espionage coming up, what the circumstances were, what we know about the individual, and then we ask whether or not there are any foreign policy objections. In this case, we also asked the State Department to advise us whether Zakharov enjoyed diplomatic immunity or not. And we got the second answer right away. We had several days, and we got the other answer, no foreign policy objection. That decision had been cleared at least by the third-ranking official in the State Department, the Undersecretary. We also took the trouble to go to the National Security Council to make sure that the National Security Council was aware of our intentions and could assess what we were doing against the other things, including the summit. It's been my strong view that we do not make foreign policy calls. We're tasked to detect, identify, neutralize the effect of hostile intelligence activity, and we're going to go right ahead and do it until somebody tells us to hold. And we give them the opportunity to hold. Now, I haven't I was with Don Regan this morning, and I've been talking to John Poindexter, Admiral Poindexter on the phone, and we'll be talking to the others when I get back. But I've detected nothing in the public statements that would suggest that our policy will change. There may be circumstances where, for a given finite moment, they don't want the boat rocked, and we'll have to work with that because, after all, that's an overriding foreign policy consideration. But I think it would be a terrible error of judgment if our government should decide that we can't roll up spies anymore simply because the Soviets might take some brutal and unjustified action in their own country. The question may come in debate, should we, when we have one who's not protected by the diplomatic immunity, should we just simply expel them and forget all the criminal charges? Just kick them out of the country. Treat it like a rule of the game. You know, got caught, out, you're out, and out you go. I don't think that's true. I don't think that's the right conclusion to reach, and I hope it won't be reached. 8 years ago, 1978, 8.5 years ago, we had two Russian spies similarly situated in New Jersey, Shevner and Enger. We arrested them. They immediately arrested an international harvester official in Moscow on charges of black market money handling, something that's easy to do in Russia. The end result was that he was expelled from Russia. We did let them out on parole pending trial, but we tried Shevner and Enger. They were convicted in a public trial and given very severe sentences. And sometime after that, while their appeal was pending, they were part of a major exchange on a bridge in Germany between dissidents and Soviet spies. What I considered to be important was this. It gave the American people an opportunity to know the reality of foreign intelligence activity in a forum that has the greatest credibility of all, an open and public trial. This is not what the director of the FBI said about what Shevner and Enger did. This is not what the Attorney General said. This is what the evidence proved and what a jury decided was true. And I think that's very important in our society, that when we have a problem of national security, like the presence and aggressive action of hostile intelligence agents, that the American public be able to see it in a form in which they can have confidence that it's true and that they're not being hyped or excited or told anything. And it's better than a press release, and it's better than a formal statement by the president, and it defies an awful lot of the arguments of the host country that none of that happened at all. You'd be surprised at what these agents have to say when we catch them. We have arrested more hostile intelligence officers in the last 2 years than at any time since World War II. Something like 27, I believe, have been arrested. All but one has been convicted. 20 have been, with diplomatic immunity, have been expelled as persona non grata. We're getting better at finding them, and we're getting better at demonstrating the extent and scope of their activities. So that I expect that we will continue. We will certainly look for them. We will expect to arrest them if they don't have diplomatic immunity, and we'll certainly take charge of them and have them expelled if they are protected. Well, I wonder if you aren't beginning to wind down. You've been very, very patient, and you've stayed a long, long time. It's been a great treat for me to be here, and I appreciate the questions. They've been good ones. And I hope, at least in the case of the law students, I'll have a chance to see you for the next 2 days. Thank you.
Thank you, Judge Webster, on behalf of us all, and thank you, the audience, for coming and contributing so much to the afternoon for us.